Asymmetrical Haircuts Justice Update with Janet Anderson and Stephanie van den Berg in partnership with justiceinfo.net.
Hi, Steph.
Hi, Janet.
So, my goodness, there have been more Syria justice developments in the last couple of weeks than I've seen for many, well, it feels like for many years. Maybe we can kick off with one of the things that you've been doing in your day job for Reuters.
Yeah, I looked at a CJA report for the Commission of International Justice and Accountability called Assad's Ghosts, where they show how the Assad regime in the early years of the Syrian conflict, so from 2011 onwards, was essentially instrumental in setting up, training and arming the so-called Shabiha militias. And what makes CJ interesting, of course, is that they focus on linkage evidence. So they really have what they say is a paper trail of orders and directives from Syrian government agencies that track the developments from the very early days of the protests that eventually devolved into civil war until the kind of formalization of the Shahiba, where they were incorporated in the National Defense Force, which is essentially a militia that is a de facto part of the Syrian army.
And does that mean that that kind of evidence could potentially come up in cases eventually?
That's the hope, because one of the things when I talked to CJ was also that they said there are a lot of universal jurisdiction cases about militias in Syria, but quite not so many about pro-regime militias, pro-Assad militias. And of those are not any of the kind of traditional Shahiba militias. And so the hope is that this kind of linkage evidence will lead to more universal jurisdiction cases. I think the general hope is that they see that the tension for Syria is slightly waning with everything happening in Ukraine, and that by putting the spotlight on different things that they find in these files, to show basically the world that, hey, we have those files, maybe you should be doing cases with them.
Well, we have not completely taken our eyes off Syria. We've got a very big case coming up at our local court, the International Court of Justice. That's a case brought by the Netherlands and Canada against Syria based on the Torture Convention.
But there's another bit also at the United Nations. There was a big decision to set up a bit of architecture around missing persons.
This I thought was really interesting because not only have a very large number of people, I see you've put into the script 130,000, I see everywhere at least 100,000. I'm sure those figures are quite difficult to pin down. These are people who are believed to have gone missing in Syria since the uprising against Bashar al-Assad since 2011. And there's been a vote at the United Nations General Assembly to set up an independent institution to look for the missing in both government and opposition areas. So what was the resolution? How did it come about, Steph?
This was the result of a grassroots coalition of Syrian families and advocacy groups who for years have been lobbying UN member states to set up this institution. Eventually, the vote was adopted by the 193-member UN General Assembly with a vote of 83 in favor, 11 against, with 62 abstentions. And the countries that voted for the resolution included the United States and other Western nations. Notable opponents of the resolution were Syria and its key allies, Russia, Iran, and China.
I know that the details are still to be worked out, but I have read that it's called, and we have yet another acronym to add to our incredibly long list, the Independent Institution on Missing Persons in the Syrian Arabic Republic.
IMPSAR?
IMPSAR. Let's go for it, IMPSAR.
We only have room to touch on this briefly, and we obviously plan to come back to this because it looks like a really interesting model for other situations with forced disappearances. But we wanted to get an immediate reaction from survivors.
So I contacted Yasmin Mashin, who's one of the founding members of the Caesar family group. And Steph, maybe you can remind us what Caesar is?
Yeah, so Caesar is the alias given to a former Syrian military police employee, a photographer who fled in 2013, and he took with him over 53,000 photos that were smuggled out on discs and thumb drives. And the images show the bodies of people who died in Syrian detention facilities, many of them showing signs of abuse and even torture. He took those as a kind of military or as a forensic photographer, and at one point decided to start smuggling them out. The images are being used in several court cases. The website of the Syria Files Foundation says that they were used in a case in Spain in 2016 as documentation and evidence. There are legal complaints based on the Caesar files in Germany, Sweden, Austria, and Norway. There is a French structural investigation based on those files, and some of the evidence from it was also used in the so-called Koblenz trials of Syrian regime officials convicted of torture in Germany in the past few years.
Yeah, I have the feeling we should do a whole podcast just on the Caesar files at some point. I spoke to Yasmin in Arabic. Just to give you a little bit of background, she was born in Deir ez-Zor, which is north of Damascus, a couple of 100 miles away from there. And she'd lost all of her 5 brothers during the war. And here she explains to me about her brothers.
أنا تأثرت بالإخفاء القسري. هالشي هذا كان حتى قبل الحراك الثوري السوري، لكن بما أنه إحنا عم نحكي عن
She told me that Omar, who was disappeared by the Air Force intelligence in 2012, and then she actually saw his photo in the Caesar files, in those photographs in 2015. And her youngest brother, Bashar, was also disappeared in case by ISIS, is believed in 2014. She doesn't know what's happened to either of them properly since then, apart from having seen that one photo. So I asked her how she felt when she saw that photo of Omar in the Caesar files.
يعني في مشاعر كانت مختلطة بين إنه ارتحت إنه هو ما عاد يتعذب، ارتحت إنه عرفت مصيره، وبين الغضب والألم اللي رافق إنه إحنا ما عاد نشوفه.
She told me it was mixed, a kind of mixed feeling, a sense of comfort that she knows that he's no longer being tortured and that they knew actually what had happened to him. But also she felt very angry and very, very sad that she would no longer see him. She also spent some time explaining to me how the victims' organisations had come together. And when we come back to the subject, maybe we'll do that in a bit more depth, why they'd come up with this as one of the mechanisms that they thought might be useful, why they were lobbying for this. They feel it actually as a crisis, that they really don't know the fate and the whereabouts of all these individual missing people. And she told me that UN resolution creating this new institution would actually have this structural participation for victims and families.
بالبداية وحسب ما كان بالقرار بأنه راح يكون في هيكلية لمشاركة الضحايا.
But as we've said, there's still a lot to be worked out and about how this institution is going to be, and they were expecting to have consultations directly with the NGOs on exactly what its terms of reference are going to be. There'll be a lot of challenges because nobody knows exactly who is going to work where, how the partnerships will be formed, how it will work with the other existing mechanisms on the ground. And they're kind of being quite clear-eyed as to whether it's all actually going to be in line with what the families of victims want and whether it's really going to be in line with their expectations. So she was going to limit her expectations at this point, which sounded really sensible to me.
Meanwhile, we're keeping a close eye on what is happening at the International Court of Justice. There is a case there, which is a long-haul situation that we were aware of for several years, but is now really starting to come out. By no means a quick fix, but the Netherlands and Canada have filed a case against Syria at the ICJ, that we also like to call the World Court, taking it to task because they said that Syria is breaking the UN Convention against Torture.
Quick stop press from me here. After recording this podcast in July, the International Court of Justice announced that the provisional measures hearings will now be in October rather than this month. We always know that dates can change, but the substance remains the same. Back to Steph.
This is kicking off with provisional measures hearing, which are kind of emergency measures that countries can ask the court to order measures to make sure that things don't get out of hand anymore until they can hear the case on its merits. And that usually takes several years at the ICJ.
I gave a call to Kira Weigard from the University of Leuven to ask her a bit about the background and specifically what kind of references Canada and the Netherlands are using to other cases at the ICJ. One that she mentioned is the Myanmar-Gambia case, but the other is the Belgium versus Senegal case, in which Belgium institutes some proceedings before the ICJ alleging that Senegal was in violation of its obligation to prosecute or extradite under this Convention of Torture. And the judgment in that case was the first time in the history of the ICJ in which it found that a state had standing, in this case it was Belgium, based on the obligations under the Convention on Torture, and the obligations are ergo omnes partes, this kind of very strange Latin phrase. So I asked her exactly what does this phrase mean and how does it link to this and maybe other future cases.
The most important one is obligations erga omnes, which means obligations that you have towards the entire international community. Then you have obligations erga omnes partes, which is not the same and which is to be seen more in the context of certain treaties, such as the Convention Against Torture, but also the Genocide Convention, where you as a state party have obligations towards all the other state parties as a collective to that treaty. They really tie you to what is in that treaty, towards everyone else who is also a party to that treaty. And so that is what the ICJ decided in the Belgium v. Senegal case, that in the context of the Convention Against Torture, these obligations, erga omnes partes, exist. Canada and the Netherlands also refer to another case, and that is the Gambia versus Myanmar case, where Myanmar said that the Gambia lacked standing to bring a claim concerning acts that had nothing to do with the Gambia or with Gambians. And there the ICJ again said the Genocide Convention status as a treaty with obligation, erga omnes, so owed by each state party to all others collectively. And so in that context, each state party has an interest in compliance with the treaty. And so the Gambia was able to bring this claim against Myanmar to the ICJ because of, again, these obligations, erga omnes partes. And so Syria, Canada, and the Netherlands are all parties, state parties to the Convention Against Torture. And so it's on the basis of these obligations, erga omnes partes, that Canada and the Netherlands have now said that they instituted proceedings against Syria for failing to fulfill its obligations under that convention.
And so the Netherlands and Canada have filed this case at the ICJ. And we also asked Kira, what exactly are the Netherlands and Canada asking the court to do?
Canada and the Netherlands have made 7 provisional measure requests, and they're quite elaborate. So they ask, for example, that Syria immediately take effective measures to seize and prevent all acts that amount to torture. But they also, it goes much further than that. They also say that they want that Syria shall disclose the location of burial sites of persons who died as a result of torture, that Syria should not take any action which may aggravate or extend the existing dispute. So they really ask a very comprehensive set of measures, which it will be very interesting to see if the court grants all of those measures. It was interesting to see that in the Gambia-Myanmar case, the Gambia also requested quite an elaborate set of measures, and the court granted most of them, if not all of them, and all unanimously.
So we decided to catch up with Toby Catman and Ibrahim Olabi of Guernica 37 Chambers. Now, they are best described as lawyers who have been assisting the Dutch government in bringing this claim to the ICJ, and we had a separate conversation with them, which we'll play you now in full, but we started with asking them to explain to us the substance of the case at the ICJ.
In a nutshell, Syria is party to the Convention Against Torture. So are many other member states, including the Netherlands and Canada. Torture, even prior to 2011, was very prevalent in Syria. The Committee Against Torture, the treaty body that looks after the convention, in a way, has made findings against Syria very clearly. But after 2011, numerous UN documents, Commission of Inquiry reports, and many other international organizations, including victim and survivor organizations, have been talking about the mass and systematic scale of torture in Syria, which is a crime in itself under international criminal law, but also a breach of the Torture Convention. And what this case is about is the Netherlands and Canada invoking Syria's responsibility under the Torture Convention, which allows any party to do that against another party if there is a dispute as to the application of that convention. As you know, torture is also defined very widely. It's torture and other inhumane and cruel acts. And so the Netherlands and Canada have also made this about sexual violences and enforced disappearance and even the use of chemical weapons, which in a way, the way the victims suffocate can also amount to at least in degrading and inhumane treatment. So it covers a very wide range of issues that would amount to torture over a very large, also kind of temporal time frame since at least 2011.
And just to add to that, I think one of the reasons why it's important is it's because it's a question of state responsibility. What we've seen are a number of cases under universal jurisdiction where individuals within the Syrian state apparatus have been held responsible before a court of law for individual acts of torture, whether that's amounting to a war crime or a crime against humanity. But what we haven't seen is the Syrian state being held responsible effectively for its policy of using industrialized torture to crush what was a peaceful revolution.
I follow a lot of ICJ cases, and this is I think the first, at least that I've seen, based on the Torture Convention. Why isn't there such a case before, and why did you eventually land on the ICJ road to look at accountability for torture in Syria?
I think many of us had been looking at different routes to accountability for Syria. Obviously, there had been the disappointment of the UN Security Council being able to refer the matter to the ICC. And there had been obviously the difficulty in getting the senior perpetrators before courts around Europe through universal jurisdiction. So I think that there had been that vacuum of accountability. And the Netherlands in particular, who we have supported through this process, have always taken a very clear line that they will pursue all avenues for establishing accountability for the Syrian conflict. It is right, and as you have followed the ICJ proceedings, you are quite right that this is the first case of its kind. The other case that was brought under the Torture Convention was quite different in that was between Belgium and Senegal for establishing a route to hold the former Chadian leader responsible. So that was really the first case, and this is, I think, untested territory, and it's when you have two states that are not directly affected by acts of torture, but invoking the Torture Convention. I think Ibrahim and I have discussed this on numerous occasions as to not only in the context of Syria, but in the context of many situations where torture is industrialized and prevalent, why this hasn't been used before. The interesting aspect of the Torture Convention being different to some of the other treaties that have been tested before the ICJ is that when the convention is ratified, you don't opt in, you actually have to opt out. So there is a provision that gives jurisdiction to the ICJ, and it may well be that states were not aware of their responsibilities because they hadn't actively opted into ICJ jurisdiction. It may well be that we will see a raft of states seeking to run away from the jurisdiction of the ICJ, but as I'm sure you know, that will not have any impact on past acts of torture. But I honestly do believe that This is uncharted territory for many states, and we really have to applaud the Netherlands and Canada for identifying this and taking the matter forward.
It sounds like you've found a kind of a dream route that nobody else had thought of before, but surely there must be some downsides to this route. I mean, one that I can think of is that it just takes forever.
Well, what I would say to that is, and unfortunately, given the kind of political landscape surrounding justice for Syria, there is no one route that can be taken. It's more kind of an ecosystem of different processes and points. So you had some universal jurisdiction cases. You even had some sort of accountability at the OPCW with suspending Syria's rights and privileges there. There is now a file sitting on the desk of the prosecutor of the ICC with regards to forced deportation from Syria to Jordan, similar to the Myanmar, Bangladesh examples of trying to look at what made people flee the the south of Syria onto things. So it's really going wherever routes are open and trying to open new routes in the process. But obviously every route, as you said, has a downside. For example, this is a case of, this is not a criminal court. It's about state responsibility, which is incredibly positive because it kind of invokes the entire system, the entire apparatus. It's not just about one individual, but it's also there is no kind of a prison sentence at the end of it. That said, that in itself, that process can trigger a lot of prosecutions in different European countries, can actually, because torture is both a crime and kind of if you like, a civil obligation that Syria owes under the convention. So in a way, even the downsides of or what this case is, I wouldn't call the downside. It's something that the case cannot achieve, or the court cannot achieve, because it's not a criminal court. It lays a very strong foundation for criminal proceedings, because it will look at torture at a state kind of level, and then people who are involved with those states, with that state, would have a difficult time saying, we were not kind of linked to it. The other issue that you raised in terms of time, again, a lot of these processes, as you know, are in themselves the outcome. When people say, I want my day in court, they're not saying I want necessarily the outcome, right? They're saying I want to see the process. I want to see the wheel, to start spinning. And given the sheer amount of evidence and the sheer amount of issues, time in this situation is not necessarily a negative factor, because it keeps the issue on the table. It keeps shedding light on the problems. It keeps showing the volumes of evidence, from sexual violence to rape to enforced disappearance to chemical weapons to torture to everything that happens in kind of detention centers, on the table through a long period of time. So actually, in this case, if survivor groups and victim groups keep shedding light on the process in itself, I wouldn't see it as a downside.
Just before we move to Toby, who wants to add something to it, I just want to say, for our readers who might be all versed in all the legal acronyms, but not so much in the others, the OPCW, of course, is the Organization for the Prohibition of Chemical Weapons, where they're also researching alleged attacks with chemical weapons in Syria. And that was what Ibrahim was referring to. And now back to Toby.
Thank you. Just to add in one point, I think, as Ibrahim has said, that there is very limited downside to the process, other than obviously the time it takes. And I think the important thing to stress is the process rather than the end result. But I think one of the ways in which, or I would say two ways in which that any downside can be effectively managed. One is by involving civil society and the victim community in the process, so that they feel part of that process. The other point is managing expectations as to what can and what cannot be done in this process. And I think certainly in our work in supporting the Netherlands, one thing which I would say both of those issues have been at the forefront of the mind of the team at the Netherlands Foreign Affairs Ministry in ensuring that people understand the process, that the Syrian victims community understands the process, understands what it can do, understands what it can't do. As Ibrahim has quite rightly said, it's not holding individual criminal responsibility, but it is state responsibility under an international treaty, which is essential. I think one of the issues that Ibrahim and I have certainly encountered is ensuring that those who may be critical of the process actually understand the process and understand what it can and what it can't do. And so that way, I think you are not only managing their expectations, but also educating those who would seek to criticize this process, what it is actually for. And I think that's incredibly important.
You've touched both on the role of the Netherlands and Canada in this as a kind of initiators, at least of the ICJ process. Why these states? How did you land on them? Is this some kind of an idea that you shopped around several states and they were the ones that bid, or is it organic desire from the Netherlands to do this, or from Canada?
Well, what I can say to that is the Netherlands and Canada are both countries that have engaged civil society quite extensively from the beginning of the conflicts. And ideas come about in different ways, but the Netherlands and Canada were very appreciative of finding routes. And then when this route came along and took it seriously, the Netherlands initially and then Canada joining, kind of exploring it. We can't obviously speak for other states, but these are not countries that were not engaged in Syria, that did not support human rights in Syria, that were not funding human rights organizations, that were not engaging victim organizations. They were doing all of that. And, when the opportunity presented itself, they were very keen on kind of finding ways to make it to make it happen. And it's they're countries that also are before the ICJ. My understanding is that their kind of engagement is also very, very limited, historic engagement, which again shows their willingness to kind of go into a new territory to push and how much torture matters for the international community as a whole. As an obligation that is owed to the international community. And throughout the process, as Toby has said, both the Netherlands and Canada have engaged Syrian groups after even they've initiated the responsibilities. Workshops were held, bilateral meetings were happening. As I said, they already kind of engaged through the international independent investigative mechanism, the IIIM. They're both supporters of those processes, and again, they directly fund Syrian human rights organizations since very, very early on. So they're not kind of your random candidates that decided over a day. They were always looking for routes, and then when the idea came up, they kind of workshopped it and moved it forward.
We try to make the podcast sort of a little bit timeless occasionally. Of course, sometimes it's all to do with the news, and we're recording now on the 10th of July and I'll put it out at the end of this week. And I'm wondering, do we know whether you will see Syria in the court, in the Great Hall of Justice or not, or how they might be represented? I'm getting already some shakes of heads. Maybe you could tell us what's known and what's not known.
Perhaps I could jump in first and then I'll let Ibrahim come in afterwards. But certainly what is clear from what's already been disclosed publicly by the Netherlands and Canada in their joint statements is that there have been in excess of 66 diplomatic notes between the parties. There have been 2 in-person attempts to negotiate the dispute as the Torture Convention requires. But when it came to arbitrating the dispute, which is obviously a further requirement under the convention, there was insufficient engagement, which is what prompted the filing and the request for issuance of provisional measures. At this stage, there is no publicly available information as to whether Syria will be defending. What we've seen in some of the other matters, particularly involving Russia, is that they will engage in the provisional measures hearing, but then there is a lack of engagement in the full process. So that, of course, is a possibility. That is speculation, of course. We simply do not know whether Syria will attend and will defend, and whether they will instruct a legal team to act on their behalf. I think what we can say is that obviously there has been a great deal of effort by the Assad regime to push for normalization and re-establishment of diplomatic ties. Obviously, the Netherlands in particular has not engaged in that process. But I think there are 2 issues. First of all, the normalization. But second of all, this is the highest court of the United Nations. And regardless of whether Syria engages or not, the process will go forward. And obviously, if Syria refuses to engage, the matter will go forward. And I mean, it's almost a matter of default judgment. You still have to prove your case, of course, but it will go forward by default with no defense. So I think the likelihood is that Syria will need to engage and will be pressured by some of its diplomatic partners, such as Russia and Iran, to engage in the process. But at this stage, we simply do not know.
Yeah, I think we can see if Syria is taking the hints from Russia and Iran, you can see that they are engaging in ICJ processes. In the Ukraine case, in Iran versus US, they are Iran quite proliferous now at the ICJ. So maybe Syria will also see this as an opportunity to vent their standpoints or their propaganda, I think you could say, at least in the case of Russia that we've seen. What are your expectations now? There is a hearing for the provisional measures, so our experience is that the ICJ at the very least will say something that you don't aggravate the dispute for both sides and sometimes gets more specific. What is the dream scenario for you, Ibrahim, in this case of provisional measures? And then, how long do you think the long grind will be to have an actual hearing on the merits?
I mean, I slightly wouldn't use the word dream scenario because I mean this is all a nightmare. This is all torture. This is all a horrific situation that is ongoing on. But at least what we would hope the court to be able to kind of give an order on is anything. The list that the Netherlands and Canada came up with is very reasonable. I mean, stopping torture, ending arbitrary detention, ending enforced disappearances, allowing access to detention centers. These are in any case obligations of Syria before it's not something new. These are international obligations that Syria already has under various conventions. It's not some sort of groundbreaking request that the Netherlands and Canada are making. So our hopes would be that these would, the court would find these reasonable because they are life preserving. We're talking about detention and torture that is ongoing now. This is not something that we're just dealing with a past scenario. So anything in that direction would be incredibly welcome. It will put legal pressure on Syria to comply with these requests in that sense. And again, in terms of timeframes, obviously the ICJ is very stretched and there are a lot of cases ongoing. You mentioned Iran previously. Iran just kind of started proceedings against Canada, to which Canada started proceedings alongside the UK and other countries against Iran. It's quite a kind of a legal battlefield these days. But again, for me personally, time and how long this takes on the merits is not necessarily an issue specifically because it's more the process itself keeps the issue on the table, and then the outcome gives you the kind of final judgment. So as long as kind of victim groups and survivors are able to see the benefit of the process and are able to make the best out of the benefit of the process, then time is not really of the essence here in that sense. The interim measures are definitely of where time is sensitive because these are things that are ongoing. But once we get to the merits and so on, it will be kind of a long road, but that's not necessarily a bad thing in this situation.
Toby, before I'm sure you want to add something to this, but I wanted to ask Ibrahim, do you think that the Syrian regime still cares about kind of the international legitimacy and what the ICJ might say about them? Are they still at the point where this is a consideration?
No, so I personally believe, and from watching how Syria interacts with the international community, that they've never given up interest. They were always present at the UN. They were always making, detailed speeches. They were responding to UN special procedures. They were responding to treaty bodies. They were responding to the Universal Periodic Reviews. They attend the OPCW meetings. They push back and so on. And so they've never wanted to be kind of a rogue pariah state in the international community that doesn't care about what the international community says. They always said, we are a founding member of the United Nations. And particularly now, given that they kind of welcomed coming back to the Arab League. And I think that was an interesting test to see whether they really care on being, rehabilitated into the system. You might have seen the invitation that the UAE unfortunately extended to Syria to attend COP28. And so they definitely care about, being seen as a legitimate state, as part of this international community. and so on. And so this makes this case even more complicated for them, because if you don't engage in the, and the ICJ is very good at reminding you of that fact in their press statements, say, the ICJ, the principal organ of the United Nations, so if you do not engage in that process, you're seen as a state that's delegitimizing itself. But if you do engage, then you also have to deal and face the horrific abuses that you and your security system and security apparatus have done towards your own people. So it's not politically, it's not an easy situation out for Syria either way.
I mean, certainly, as far as what we would want to see through the process, I think there are two things really which are particularly important. One is when you look at some of the requests that are being made, it is not only to ensure that the tens of thousands who are still detained as political prisoners have some form of resolution to that. And I know that we're dealing with a very difficult situation where we're dealing with the Assad regime, and so nobody from the Syrian community is going to have any confidence in any process. But I think at the same time, what we do want to see is that political prisoners at least have a way to effectively be released, and that there are mechanisms that are going to be established that will deal not only with the judicial oversight, but also the adjudication of claims, and also the holding individual perpetrators accountable. And I think that through the interim measures, I think that those are some of the sort of the most important aspects of what is being pushed for by both the Netherlands and Canada. We don't just want to see a 500-page ruling from the ICJ holding Syria accountable for breaching the Torture Convention, which we all know, and of which the evidence is overwhelming. What we want to see is concrete results come out of that, where there is a process that is going to be established for the longer term. And I think one of the things that Senator Ibrahim and I have spoken about extensively in this is that this is a long-term process, not just the proceedings of the ICJ, but the adjudication of these issues. And quite frankly, when we look at past conflicts, the long-term rehabilitation of torture survivors is something which is quickly forgotten. Once we hold a handful of perpetrators accountable, we don't actually think of the victims anymore. And I think that's why this process is particularly important for Syria, because it's going to have to rebuild itself. It's going to have to reestablish the necessary institutions that will transform, we hope, Syria into democracy, but also have those institutions that have been so lacking, which are the judicial institutions. And I think this process, and maybe we are shooting for the stars now, but I think that's what we want to see.
I think it's really interesting, as Ibrahim said there, the way that the ICJ is becoming one of this main legal battlegrounds, because I also asked Kira exactly about how come the ICJ is so busy at the moment. She pointed out that there are many different countries who seem to want to use the court. It's not just being something where, to use those awful phrases, global north countries are bringing stuff, but it's also something where a big range of countries, including very small countries, are making use of the court's facilities. And this is part of what's making the court so busy.
It is extremely busy. The court currently has 18 pending cases, and 2 are being heard or under deliberation. 4 were instituted this year. And of those 4, 2 are advisory opinion requests. So we also see that the court is really being seized by many different actors. And then on top of that, you have all these interventions in the Ukraine-Russia genocide case, where now we're going to have 32 states submit written observations, which is also a huge challenge to what the court then also calls the good administration of justice, to make all of this go smoothly. And so it's extremely busy. As part of my research in the last 2 years, I've asked a number of those judges also about their workload and how they would assess their workload. And most of them told me that their workload was fine, that it was a full-time job, but that it was doable. I do wonder what they would answer if I would ask them this summer, if I would do another round of interviews. I think the answers would be very different. And of course, then there are elections at the end of the year. So that also has an impact on when the court can schedule hearings and when it can deliberate.
And on top of that, we have ICJ elections coming up that may also get in the way of several hearings. And it's interesting what happens to some of the stalwarts of the court, including the Russian, I think he's vice president of the court at the moment, Gevorgian. Will he stay on?
Yeah. What do you expect, Steph? Are you going to be watching the elections closely?
Probably not as closely as other elections that are going on in my patch of reporting. But I think it's always interesting to look at it. It's always hard to make news out of it directly. But the way the voting goes does show which kind of countries are in attendance and which are not, and how these things can play out in the court. I think maybe off the top of my head, I think it might be interesting for an institution as the ICJ to keep a Russian judge, just as they have a Chinese judge on hand, so that they could never get this, this obvious criticism that they're shunning these kind of countries. So if you have these people of what I think we can kind of safely say are occasionally problematic countries in international justice, have them on the court, and especially because you now have an American president, you want to counterbalance that with some other people who are not so easily dismissed as capitalist U.S. pawns. If we go very, very straight to the point.
So I imagine that we will keep on top of what is said in this particular case, because it does seem to be quite a significant one. If this route of using the torture convention in the Syria case is kind of established as a potential route, then potentially we might see some other cases using the same convention at the ICJ brought by other countries. So I can imagine, along with so many other things that we have to cover, that we're going to have to follow this one.
Yeah, especially because Toby explained that you'd have to opt out of this, which is unusual for these treaties where you don't, you usually have to opt in for ICJ jurisdiction, but here you have to opt out. So that may be past a lot of countries. But the question then also is, how big is the appetite for countries to kind of take the lead and take other countries to court over torture? Because obviously Syria is not the only member of the Torture Convention that actually does things that could be legally amount to torture, and yet they're the only ones in all these years that have been brought before the ICJ. So I don't know how big the appetite is to go after all these countries, but I'm sure if this works, a lot of human rights organizations will push that route, and we'll see which countries want to get activists at the ICJ over that. Okay,
onwards and upwards.
Onwards and upwards, always stuff that's for us to do. We keep being busy over here, but we love it. So we'll keep you updated on all the other court cases going on in our patch.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie van den Berg. This episode was produced in partnership with justiceinfo.net, an independent site covering justice effort for mass violence. This episode was recorded at the Hague Humanity Hub, home to a community of innovators in the field of peace, justice development, and humanitarian action. Music is by audionautics.com, and you can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.
Hi, my name is Fritz Streif. I'm a human rights lawyer and a long-term listener to the Asymmetrical Haircuts podcast. International justice is my passion, so much so that, like Janet and Stephanie, I also started a podcast, which you might like as well. It's called This Syria Trials, and each episode looks at a different part of the struggle for justice for Syria, a country that has seen unspeakable levels of violent criminality since the revolution began there in 2011, and which now finds itself in a, let's say, awkward process of what some call normalization. We have a series in English and a series in Arabic. You can listen to the whole of the first seasons of each series now. Just search for This Syria Trials wherever you usually get your podcasts, or head to our website 75podcasts.org, where you can also check out our other productions and find transcripts of all episodes.